Hi, I'm Michele Weiss. I'm a tax controversy attorney at Holt, Slavin & Drapkin. I'm a former IRS counsel attorney, and I'm currently on the other side of the table. I represent my clients before federal, state, and local taxing authorities administratively in exams, collections, appeals, and also in litigation matters. And today I'm going to talk to you about the IRS's employment tax initiatives. They've stepped up their efforts in that area, and I will educate you about that right now. So the IRS has employment tax compliance initiatives. As I said, the commissioner has announced that it's a priority for the IRS. The IRS collects over 70% of its revenues from employment tax withholdings, and so it is a very important area. The thing to focus on is that it's a collections and criminal investigation division campaign. Both the criminal investigation division chief and the collection chief have stated how important it is. And the thing to focus on here is we're not looking at the independent contractor versus employee classification. In this situation, there's employment tax. The IRS isn't questioning the amount of the employment tax. They're questioning how much is collected. So the IRS has had a couple special campaigns. They had one most recently from March 25th to April 5th this year. The collections division had revenue officers visiting over 100 businesses nationwide that they identified as having serious compliance problems. They educated these businesses on how to pay back payroll taxes and become compliant, and they also educated these business owners on civil and criminal penalties for employment tax violations. During the same period of time, the Criminal Investigation Division worked with the DOJ around the country to focus on 50 law enforcement actions related to employment tax crimes. There were 4 search warrants that were executed, 12 indictments, 6 criminal sentences for crimes associated with payroll taxes, and they said there will be more to come in the following weeks, and there has more that's gone on since this special campaign. So on the civil side, the way that the IRS Collection Division is able to pursue things is through something called the Trust Fund Recovery Penalty. And what this Trust Fund Recovery Penalty is it's an individual liability for businesses' unpaid employee withholding. So in this situation, the entity had a responsibility to collect and pay over employee withholding, but it failed to do so. And it creates personal liability for the trust fund portion of the employment tax, which is also known as the amount of the employee's withholding. The issue is that these amounts were actually collected. The business entity is really standing in the shoes of a fiduciary relationship with the government. They collected the tax and they needed to pay it over and they didn't, so they failed. And the personal liability, the trust fund recovery penalty, will apply to a responsible person who willfully fails to collect or pay employee withholding. A common situation for a responsible person of a company in financial distress, and the usual situation is that business uses their funds available to pay creditors rather than employee withholding. To give you some more information on this one, who is a responsible person? It's a person who has a duty to perform and the power to direct the collecting, accounting, and paying of trust fund taxes, such as withholding. So there are different factors that courts and the IRS will look at. It's not just a matter of someone's title, but that is one aspect of it. There are all different factors. The position for example, the position in the corporation, authority to sign checks, control over financial affairs, ability to hire and fire employees, discretion over which creditors are paid, day-to-day management of the business, and so on, and preparation of or signing of employment tax returns. And in some situations, the responsible person is not even necessarily an employee of the company. It could be an accountant or a financial advisor who is performing these functions for the company. So here are some examples of a responsible person: an officer, a corporate director, a shareholder, a board member, or any other person with authority and control over the business's disbursement of funds. So we're not talking about someone who's sitting in a cubicle and processing paperwork. We're talking about probably the person who is at the top level of that division who actually has the authority to decide who's getting paid and for what. And a really good example of this is a very recent case, Dixon v. Commissioner, which was decided this year. And in this situation, Dixon was the son of his parents who were indicted for tax crimes. And the question was whether he was a responsible person for unpaid employment tax of this particular company. So the court broke up his tenure into two different periods. The first I will call the earlier years, and the second period I'll call the later years. In the earlier years, the court found that the son was not a responsible person because they found that his parents ran the company. They had his son sign documents at their request. The son spoke to his parents about the company's employment tax liabilities, and the parents said that they would handle it. And at that point in time, the son worked more on the operations side of the business. So this happens a lot where you have someone, let's say you have a construction company, and you have one person who's the contractor who's always running out to the buildings, and you have somebody else who's in the office managing the administration. It's that administrator person who's going to be the responsible person much more so than the contractor. Even though the contractor might be signing checks once in a while, he or she is not really overseeing the administration of the company. However, in this situation where first you had the earlier years where the son was working for the parents and really under their wing, they found that this was, quote unquote, in stark contrast to his role in the later years where he had signatory authority. He became the president and sole director of the company. His parents were grooming him to take over the company. And he was involved much more in the day-to-day operations and in the tax liabilities and payment tax liabilities involved for the company. So those are examples of a responsible person. The other factor that you need to have is you need to have a responsible person who willfully failed to pay over the tax. So what is willfulness? So general definition, the person was aware of the business's employment tax liability and intentionally disregarded the law or was plainly indifferent. So to be more specific, it involves a voluntary, conscious, and intentional act. So for example, consciously choosing to pay other creditors rather than the IRS is evidence of willfulness. One case involving this is Schumacher v. U.S., where the court found that allowing other bills to be paid when one is aware of outstanding tax liability demonstrates willfulness. There are some circuits that allow a reasonable cause to willfulness. The Ninth Circuit does not. It specifically rejected it. Willfulness includes a reckless disregard of an or known or obvious risk that the trust fund may not be remitted to the IRS, and knowing about a company's financial distress should alert a responsible person of the risk that withheld taxes are not being remitted. So here are some examples from some cases. In Ray Gregory Rutherford, where a responsible person knows about the company's financial distress but fails to take reasonable steps to learn if the trust fund taxes are remitted to the IRS. A responsible person cannot immunize themselves from the responsibility by wearing blindness. That's a concept of willful blindness. Also, there's another case of Mary Phillips, where a responsible person fails to investigate or correct mismanagement after being notified of a default in payment of withholding taxes. Now let's compare this to the case of Frank McCagnoni. In his case, he was not found to be willful. Even though he was the president and 50% shareholder of a failed corporation, he did not know of the corporation's employment tax failures until after the company had failed. And so the court found his failure to inquire about payment of taxes was not reckless disregard because the corporation did not have a history of tax delinquency. So what the court is looking for is situations where the person says they didn't know, and was it reasonable for them to not know? Was the company in financial distress? You can't just say that you didn't know when it's so obvious that if there's financial distress, perhaps taxes aren't being paid. Another case of Robert Landau found that narcotics and alcohol addictions do not absolve willfulness. The court found that the failure resulted from a voluntary use of narcotics and alcohol, and of course this discussing whether that's true is a subject for a different day and a completely different topic, but that also does not absolve you from willfulness. So there are some limitations on the trust fund recovery penalty, very small window, where you can show that you're only responsible to the extent that the company had sufficient funds to pay tax, which means that you're not responsible to pay tax that exceeded the funds under the responsible person's control. In this situation, you need to prove that the taxpayer was legally obligated to use the funds available for a purpose other than tax, and that the legal obligation was superior to the IRS's interest in the funds. This is a very narrow and very rare exception. There are a lot of cases on this, and in general, courts have found legal obligations superior to the IRS interest where the obligation was to a state trust fund. There are a couple of cases on that. But obligations to private parties, such as creditors and employees, are not superior to the IRS. So just in a nutshell, if this frequently comes up when companies are in financial distress, that the company is just trying to stay alive. And so the president of the company, and I have clients that come to me with this all the time, I had to pay the rent, I had to pay my employees, my business couldn't go on functioning. And the IRS will say, no, we come first. You needed to pay us first. And there is something called the government priority statute, which does give the government this authority. And so in those types of situations, it's usually there's financial distress, and so the money's being used to pay things other than tax. Now, here's a situation of criminal liability, and it is much more rare. The IRS is increasing its efforts in criminal enforcement of employment tax collection. And remember, this is a collection. This is not a classification issue. This is a collection issue. The factors that could lead to criminal liability are large amounts are due and owing, it's over multiple periods, and the funds are being used perhaps for personal expenses as opposed to the business expenses. Now, here's an example. The amount of money is low, but this is what happened. There was a recent indictment, and the person pleaded guilty, and it was only for $68,261 in unpaid employment tax. Now, normally, if a client came to me and they told me that this was a liability that was outstanding, I would say, oh, it's unlikely. People are always saying, oh, well, I have criminal liability. It's really unlikely for such a low amount. And his sentence was not that stiff. It was 3 years of probation with 8 months of home detention. But it did involve 7 quarters, so it was over a long period of time. So he was a repeated offender, even though each quarter wasn't all that much money. But here's the kicker. He used the funds to pay personal expenses, including expenses for his race car hobby. And so in this situation, he's not trying to keep his business alive. He's using his stuff for personal expense, his personal use. So the government is looking at it. If you're stealing our funds for your personal benefit, that's crossing over a line that's much more than just using it for other creditors in the business. So it's no longer a trust fund recovery penalty, it's criminal liability. Also, in the course of this case and the pleadings, the taxpayer admitted that he knew that taxes were due, but he chose to spend his company's money on other things, meaning on himself. So that's the difference here, is it's taking it to a different extreme. So one other area that I wanted to talk about in employment tax is that there's been a major overhaul of Form W-4 by the IRS. It's coming. They're in process. It's to comply with the Tax Cut and Jobs Acts of 2017. Currently, the W-4 that's in place is based on exemptions that were eliminated by the Act, by the new tax law. And so the IRS released its first draft for comment on May 31st. It eliminates exemption-based withholding calculation, and it gives itemizing employees an opportunity to estimate their deduction. So here's a copy of the draft. It's open to comment right now, and you can see it reads a little bit more like a little mini tax form. There's no place for exemptions, and you can try to you can tailor it to yourself. You can try to add in what you think your deductions will be so you can get a more accurate view of how much you're going to owe. And so what does this mean for employers? Well, employees don't need to file a new W-4 if they already filed an older version of the W-4. So that's a relief for employers that next year they won't have to suddenly refile this form for their entire workforce. However, they will need to use the new form for W-4 for new hires starting in 2020. And what that does mean is employers will need to bring their payroll systems to comply with the new W-4 to avoid employment tax withholding liabilities. And so here again, they're being confronted with a situation where they need to bring their system up to date to make sure that they comply with the new rules. And of course, it's optional if there's an employee who wants to refile a W-4 so that their withholding aligns more with where it should be, then the employer is going to have to be able to comply with that. So if you have any questions about employment tax withholdings and liability, please feel free to contact me, Michele Weiss at Holt, Slavin & Drapkin, and I look forward to hearing from you with any questions. Thank you.